A beautiful Friday morning to our MLGU participants. Before we start, may I request everyone to give us a quick thumbs up just to be certain that you can hear me loud and clear. To start our program, let us put ourselves to the holy presence of our Lord Jesus Christ. Lovingly Heavenly Father, we come to you at this hour asking for your blessings and help as we gather together. We pray for guidance in the matters at hand and ask that you would clearly show us how to conduct our work with a spirit of joy and enthusiasm. Give us the desire to find ways to excel in our work. Help us to work together and encourage each other to excellence. We ask that we would challenge each other to reach higher and farther to be the best we can be. We ask this in the name of the Lord Jesus Christ. Amen. Once again, thank God it's Friday, and welcome to the fifth and last day of the online training for the Municipal Local Government Units on Republic Act number 9184 and its 2016 revised implementing rules and regulations, brought to you by the Government Procurement Policy Board Technical Support Office. I am Janelle de la Cruz of the Capacity Development Division, and I will be your host for today's virtual activity. Before we proceed to our program, we will be giving two special tokens to our two early bird participants who has first entered the waiting room. Upon verification and validation of our technical team, we would like to announce our first early bird participant from LGU Baleno Masbate, Mr. Rodolfo Returan. Congratulations, sir. And our second early bird participant is from LGU Santa Maria, Ilocos Sur, Mr. Eduardo Fernandez. Congratulations po. Our event secretariat shall coordinate with you on how you may claim your special tokens. Again, before we start our today's session, we will have a morning activity. So we will be showing jumbled words related for the topic today, and all you have to do is to guess the word and type in your chat box. While our technical team is fixing our presentation, may we remind the participants to accomplish the OTMS evaluation by visiting the link and using the control number emailed to you by our event secretariat. Please don't forget to accomplish the general evaluation, evaluation of presentation materials, and resource speakers for days 1 to 4. And after our training, you may also evaluate for day 5. So, accomplishment of the OTMS registration, complete evaluation, and attendance through Google Form is required for the issuance of the certificate. So please don't forget po. So again, we will be showing jumbled words related for the topic today, and all you have to do is to guess the word and type in your chat box. Our first word is our Facebook viewers may also join by typing in their answers through the comment section. So our participants said procurement. And the correct answer is procurement. Ayan, virtual clap po kay LGU Baleno, Sir, I'm sorry, LGU Santa Maria, Sir Eduardo Fernandez. For the second word, ayun. Sabi ni Miss May Manibo, Remedies. Ayun din yung sabi ni Ma'am Lourdes, Sir Rodolfo, Miss Grace. So the answer is remedies. So virtual clap. Ayan. So for our third word, 2 words po siya, which is related to our topic today, which will be discussed by our resource speaker, Attorney Atis. So sabi po ni Miss May, penal clause, ganun din ang sabi po ni Miss Anna Vic, Sir Rodolfo, and Miss Grace, Miss Rowena. So the answer is for word number 3, penal clause. Ayan, virtual club po ulit. Meron pa po ba tayong last word? Ayan. 3 words naman po this time. This will be also discussed by our RP for today. So, any guest po? Kaya niyo po yan. Ayan. Nag-iisip pa po yung ating mga participants for today. Sirat na po ba? Ayun. Sir, ma'am, 3 words. Kulang pa po. Ayan. Hindi alam ni ma'am yung first. Kaya mo yan, ma'am. Ano po? Ayun, si Sir. Sabi ni Sir Rafael Diso, online blacklisting portal. Pati ni Ma'am Michelle, Miss Anna Vic, Miss Rodalisa, Miss Grace. Ayan, so the answer for our word number 4 is online blacklisting portal. Ayan, virtual clap ulit. Congratulations. Thank you for being active this morning po. And that's it. I hope all of us have a good exercise this morning, mental exercise po. So, reminders po again. We would like to remind again our Zoom participants to register at the online training management system by visiting the link and using the control number emailed to you by our event secretariat. We would also like to remind everyone to please accomplish the participants' daily attendance sheet through Google Forms by visiting the link shared to you by our event secretariat through the Zoom chat box. Rest assured that all information gathered for this online training shall be treated with utmost confidentiality, consistent with the provisions of the Data Privacy Act. So before we proceed for our today's lecture, I will just give a quick recap for yesterday's learning session. So we have a meaningful and productive lecture with Director Renato M. De Vera on the discussion about the various alternative methods of procurement and appropriate use of these methods based on the prescribed conditions, procedures, and requirements. So moving on, before we dive to the program proper, let me give you an overview of the program of activities for the 5th day of our online training on government procurement. So we will be discussing today protest mechanisms and remedies, and for the next session, blacklisting guidelines. Further, to make our discussion even more exciting, again, we will be having a series of knowledge check all throughout the session. So wherein our Zoom participants will be answering series of questions through poll, which shall be flashed later in your screens. All right, let us now move on to the lecture proper for the first topic of this online training. With that, allow me to introduce our resource speaker. It is my pleasure to introduce to you our session's resource speaker. Our resource speaker graduated at the University of Santo Tomas with a bachelor's degree in science, major in economics. He also earned his Bachelor of Laws at San Sebastian College, Recoletos. He has been working in the Department of Justice since 2003 and has been an active GPPB trainer of RA 9184 and its 2016 IRR since 2017. Joining us today, the Attorney 6 of the Department of Justice and a GPPB recognized trainer, please welcome Attorney Jainito Roy C. Atis. Good morning, sir.
Good morning, Janelle. Good morning, everyone. Thank you for that wonderful introduction. So, rinig naman ako. Rinig naman po ako.
Yes, sir. Rinig po.
Okay. Today, I'll be discussing 2 topics pala. So, okay. Good morning, everyone, and welcome to our lecture. I believe this is the last day. Last day. Grabe. Mga participants pala natin from all over the Philippines. Yan. Magandang umaga po sa inyong lahat. At ngayong umaga ay aking i-discuss, aking tatalakayin ang mga protest mechanisms and remedies under RA 9184, and for our second module, we'll be discussing the blacklisting guidelines. So, let's proceed. So, first, we have to know our module objective. So, by the end of this module, the participants should be able to know the grounds and remedies of offenses committed in relation to the conduct and or participation of procurement activities, and understand the procedures and considerations of how to resolve a request for reconsideration. So, kung first objective natin, this will serve as a guide kung anong makikita natin, yung mga remedies, yung mga offenses, yung mga bawal gawin sa under RA 9184, mga acts which are considered criminal under under this law. Guide to procurement officers, what we are doing parang is well within the bounds. Parang this sets boundaries what we are supposed to do in certain situations. So in the whole procurement process, parang yan. Kasi next we have to understand the procedures. Sa second natin, parang ito yung mga titignan natin pag in case na inano ni prospective bidder, yung ini-utilize ni prospective bidder yung kanyang protest, yung kanyang remedy under this law. Outlines. So first, I'll be discussing the penal, civil, and administrative provisions of RA 9184, yung mga liabilities, yung connection niya sa RA 3019, the protest mechanism proper, so mga requisites and yung procedures, and finally yung second part ng module natin, which is the blacklisting guidelines, which we will discuss later. So first, we go to the penal, civil, and administrative provisions. First, we have to take note na kailangan natin in-exercise, di ba, whole of government naman yan, we have to exercise the highest standard of ethics. So the standard of pero dito sa procurement, hindi lang sa ating mga procurement practitioners, but also required ito, yung highest standard of ethics, sa mga bidders, manufacturers, suppliers, distributors during procurement and execution of the contract. So the whole process dapat kailangan we are exercising highest standard of ethics. Kung hindi naman, bidders have determined to have committed the corrupt, collusive, fraudulent, or illicit practices will not be eligible to bid projects. So yan, kung under the rules, pag na-determine na nag-commit yung participants ng corrupt, fraudulent, collusive, or illicit practices, they will be blacklisted. Yan. Which will discuss also later. Yung kung paano natin magba-blacklist, mga instances ng kung kailan sila nagkaka-blacklist. So ito, yung prohibited practices natin is divided into 4. These are collusive, corrupt, coercive, fraudulent practices. Yeah. Collusive practices, this is a scheme arrangement between two or more persons, between two or more bidders to establish bid prices at artificial level. Diba? One of the purposes of this law is to promote competition. So kung nagko-collude na yung mga bidders sa isa't isa, or meron silang kasabwat na public officer, nagko-collude na sila. Hindi na natin na-utilize yung purpose ng law for competition. Kasi pag nagko-compete ang mga bidders, we are getting the best deals at the best price, di ba? So kung wala na yung competition, nagko-collude na sila, parang hindi na natin nakukuha yung best deals for the government. Hindi na natin nakukuha yung best price. Next, we have corrupt practices. This is a proper and unlawful enrichment of oneself or others, or induce others to do so by misusing the position of which they are placed, includes the offering, giving, receiving, or soliciting anything of value to influence the action of such official in the procurement process or in contract execution, or entering in behalf of the government into any contract or transaction which is manifestly or grossly disadvantageous to the government, whether or not the public officer profited or will profit thereby. So corrupt practices, this is taking advantage of our position, wherein we enrich ourselves, parang we gave undue advantage to mga parang bidders kasi meron silang consideration na binigay sa iyo. So kailangan parang we should have integrity, di ba? Parang lahat ng decisions ng mga procurement practitioners should be untainted. Diba? Kaya we designate back members, PWG secretary, to have integrity, professional integrity. Diba? So hindi sila easily swayed by mga ganyan. Hindi sila tumatanggap ng ganyan. Hindi sila nag-engage ng corrupt practices. Next would be coercive practices. This is harming or threatening to harm, directly or indirectly, persons or their property to influence their participation in the procurement process or affect the execution of contract. Dito yung parang merong fino-force mo yung isang tao na by harming or threatening that person to decide on a certain matter, di ba? So kung merong threat sa kanya or merong may mga factors na maano sa kanya na to affect this decision, these are coercive practices. Next, we have fraudulent practice. These are misrepresentation of facts in order to influence the procurement process or the execution of contract to the detriment of the procurement. For fraudulent practices, ito yung mga pag-falsify, hindi sila nag-falsify, parang meron silang hindi dinidisclose, hindi sila transparent, ba? Parang nagmi-misrepresent sila. Yan yung ito yung mainly generally prohibited practices under the law.
At this point, we will be having our first knowledge check. So may we ask our participants to select their answer via the Zoom polling feature. So may we ask our technical team to please flash the first question. The question is, all are covered by penal provisions under RA 9184 except one. A, misrepresentation, B, collusion, C, connivance, D, malicious mischief. Again, all are covered by penal provisions under RA 9184 except one. A, misrepresentation, B, collusion, C, connivance, D, malicious mischief. So we will be closing the poll in 5, 4, 3, 2, and 1. So most of the answers, sir, is 80% D, malicious mischief. Tama po ba yun, sir?
Ang tamang sagot ay letter D. Tama. Tama po. Malicious mischief. Wala naman sinabi kaninang malicious mischief. Yung connivance is also collusion. Misrepresentation, yan yung kasama dyan yung fraudulent practices. Sinabi ko na yan, kasasabi ko lang misrepresentation. Diba? Yeah. So kaya ang hindi kasama dito is malicious mischief. Kasi ang malicious mischief is covered under the revised penal law, penal code. So ibang crime yan.
All right, let's now proceed po with the lecture.
Now go to the penal provisions under RA 9184. So ito, first we discuss the coverage. This covers both public officers and private individuals. So yung if a person is charged under the criminal provisions under RA 9184, this is without prejudice to the filing of other criminal actions. So when we say without prejudice, kung na-filean ka ng criminal action under RA 9184, you can also be filed another action, another criminal action based on other laws, specifically under RA 3019. So kung criminal provisions under RA 9184 na chargean ka, pwede ka rin kasuhan under RA 3019. So this covers also all types of procurement, whether manually or electronically, under the 65.4. So parang karma lang yan, digital na. So, digital na rin. Covered din nilang digital. So yung penalty natin, ito yung lagi sinasabing 6115, 6 years and 1 day but not more than 15 years. Applicable penalty. Also, there is also an accessory penalty of temporary or perpetual disqualification from office, whether elective or appointive yan for public officials, and permanent disqualification from transacting business with the government in case of a private individual. So whether public official or private individual, pwede silang makulong ng 6 years and 1 day, but not more than 15 years. So, biruin niyo. Habang panahon, 6 years, marami-raming araw rin yun. Mahirap rin yun. So, next. Jurisdiction over offenses defined under this rule shall belong to appropriate courts according to laws existing at the time of the commission. Yan ang may jurisdiction sa ating mga. Now go to the specific provisions under RA 94. So first we go opening any sealed bid, including but not limited to bids that may have been submitted through the electronic system, and any and all documents required to be sealed or divulging their contents prior to the appointed time for the public opening of bids or other documents. So dito, under 65.1A, it's actually 65.1A. So dito, there are actually two offenses already. So opening of any sealed bid before its appointed time of opening. Diba? So kung diba, yung mga bidding documents nyo, we require it to be sealed, di ba? Sealed all over, tapos may pirma, di ba? Pinipirmahan pa yan ng mga representatives sa mga edges, di ba? So, pag inopen nyo yun, diba, bukas pang opening or sa Monday pang opening, binuksan nyo ngayon, di ba? Inopen nyo yun, that is already considered a criminal act. Mere opening. Wala naman siyang inano. Tapos, under that provision, there is also another violation or divulging their contents. So, inopen mo, that is one offense. Dinivulge mo pa, that is another offense. That is a separate offense. Diba? 2 offenses kagad dun sa 65.1A. Next would be delaying without justifiable cause, the screening for eligibility, opening of bids, evaluation and post-evaluation of bids, and awarding of contracts beyond the prescribed period of action provided in this IRR. So yung mga periods na provided under the IRR, these periods are mandatory. So we have to comply. We have to follow those periods religiously. Diba? Diba? Under yung meron tayo dyan sa IRR natin, meron siyang parang table, yung parang most, yung sagad na periods, diba? Tapos yung earliest possible time, nandun na, compute. So this provision as a general rule, delay does not necessarily constitute a criminal offense. However, if the delay is without justifiable cause, kung yung delay mo, hindi nyo na-justify, kumbaga, wala lang, walang reason bakit nade-delay. Kumbaga, hindi nyo nako-comply, walang reason, for no reason at all. Diba? Kung wala namang fortuitous event na would prevent you from complying with the periods provided for under the IRR, you can be held criminally liable. So next would be unduly influencing or exerting undue pressure on any member of the BAC or any officer or employee of the procuring entity, or to take part a particular action which favors or tends to favor a particular bidder. Yeah. So ito is sinasabi nating coercive practices. Diba? Parang in-influence ka. Certain, halimbawa si back member, tapos meron siyang boss, diba? May mas higher pa kay back member. Tapos, it so happened, doon sa bidding sa isang project, yung si bidder, isa kumpare ni boss back member. So, ito si bidder, si Raulo, kinausap si boss ni back member. So, kumpare, kasi magkumpare sila, kumpare, tulungan mo naman ako, ganyan. Kasi, merong kailangan desisyonan ng back dito para makuha ko yung project. So, kung naman si boss ni back member, kinausap si back member. Sabi niya, kinausap niya yung back member, sabi niya, oy, paboran mo naman yung decision sa bidder A. Okay na, kung basta paboran mo yan. Kasi kung di mo pinaboran yan, hindi kita ipopromote. Yan. So, siyempre ngayon, dahil si back member gusto ma-promote, so, sinunod niya yung decision. Sinunod niya yung basta. So, that is one example of unduly influencing and exerting undue pressure on any member of the back. Next would be splitting contracts which exceed procedural limits to avoid competitive bidding or to circumvent the limits of approving or procurement authority. The splitting of contract. Please take note, the GPPB issued non-policy matter 19-2020. So, anong sinasabi dito? Hindi ko nabala yung notes ko. Pero, mere division of procurement into artificial phases does not necessarily constitute splitting of contracts. So before, the fact na dinivide mo into artificial phases yung yung procurement mo, yung projects mo, that is considered splitting already. Pero under that non-policy matter opinion, so mere division of projects into artificial phases does not necessarily constitute splitting of contracts. What is important to be considered splitting is that the purpose, kumbaga yung purpose nung pag-split mo, pag-divide mo nung is to avoid public bidding, diba? Or to circumvent the limits of approving or procurement authority, diba? Halimbawa, you have to bid for the whole year 1.5 million worth of supplies. You can bid it, diba? 1.5 million. Pwede nyo silang i-divide into artificial phases. Basta ang purpose nyo, you have a valid purpose, not pwede nyo, basta hindi sasabihin na, ay para hindi na tayo mag-bidding, na lang natin, unti-untiin na lang natin, tayo-tayo na lang natin. Yan. That can be considered splitting. Pero kung halimbawa, meron kayong reason, magbibid kayo ng 1.5 million worth of for the whole year na yun. Kaya lang, magkakaproblema kayo doon sa storage. Diba? May problema kayo sa storage. So, anong pwedeng mangyari? So, sabihin yung storage nyo, kulang, hindi kasya yung 1 year worth doon sa storage natin. So, you can divide it doon sa kung ano yung kaya ng storage. Diba? Meron kayong, you're not dividing the procurement to avoid public bidding, but on certain instances na kailangan talagang you're not necessarily circumventing. Diba? Next, when the head of agency abuses the exercise of his power to reject any and all bids mentioned under Section 41 of this Act and this IR with manifest preference to any bidder who is closely related to him, in accordance with Section 47 of this Act and this IR. So dito, pag si Hope naman, this criminal offense pertains to the Hope. Kasi sa Hope has the power to reject any and all bids when there is a prima facie evidence of collusion between the bidders themselves, between the bidders and the members of the BAC, between or employees of the procuring entity, or this collusion between the bidder and the third party, so including any act which restricts, suppresses, or nullifies, or tends to restrict or suppress or nullify competition. Or if the BAC is found to have failed in following the prescribed bidding procedure, or for any justifiable reason, the ground for the award of contract will not redound to the benefit of the government of the Philippines. So, yun yung reasons. Kung halimbawa, ini-exercise ni Hope yung reasons na yun na parang in-abuse niya na kasi meron siyang gustong paboran na bidder. Kung halimbawa yung isang bidder, we have 3 bidders who were post-qualified, tapos pareho compliant naman silang tatlo, pareho sila si bidder A, B, and C. Si bidder A, ang nirecommend ni BAC for award kay Hope, di ba? Nirecommend niya kay Hope, ni BAC kay Hope yung award. Pero dahil bet ni Hope si B, in-exercise niya yung nag-declare siya ng failure of bidding para hindi ma-award kay A yung project. Kasi pinapaboran niya si B. So he uses his power to reject the bid of A in order to get the bid of B. Diba? So, yan ang example. Next would be offenses committed by private individuals. So these are so public officers conspiring with private individuals are also liable under this provision. So, ito rin yun. So first, when two or more bidders agree and submit different bids as if they were bona fide and they know that one or more of them was so much higher than the other. So dito, this is our collusive practices, di ba? These are collusive acts. Also prohibited under this law. So, ito si bidder A, B, and C. So, alam na nila, magkakakilala na yun. Usually, yung mga bidders magkakakilala na nila. For certain projects, yung mga IT, kahit pa paano dahil sa kakaparticipate nila sa government permit, nagkakakilala rin sila. Pero, halimbawa, nag-usap-usap sila si bidder A, B, and C. O sige, lagi ka naman nananalo, bidder A. Sabi ni bidder A, lagi naman ako nananalo. Sige, tataasan ko na. Para si C naman. Sige, B. So, nag-usap-usap sila. So, sige, tataasan ko na yung bid namin. Para mapunta sa iyo, bidders. Yan. Next, when the bidder maliciously submits different bids through two or more persons, corporations, partnerships, or any other business entity in which he has an interest to create appearance of competition that does not in fact exist, so is to be adjudged as the winning bidder. So ito, parang nag-create naman siya ng artificial competition. So isang collusion, nag-collude na sila, so wala nang competition. Ito naman, nag-create naman siya artificial competition. Pero siya pa rin ang nananalo. Diba? Kasi may company siya, usually man mga corporations meron mga parang members, mga stockholders na may interest sa lahat, tapos same businesses. Encourage other corporations na, sige, pag-participate tayo dito. Hindi siya pa rin naman panalo. Diba? So, artificial competition. Next, when two or more bidders enter into an agreement which call upon one to refrain from bidding for procurement contracts or which call for the withdrawal of bids already submitted. So, dito, much like the first one, much like this one above here, parang ito naman, parang pinagtutulungan nila yung isang bidder na kung dito sa una, nagkasundo sila bidder A, C. So ito namang sa pangatlo, si bidder, halimbawa nito, si bidder A, B, and C. So bidder A and B, parang pinagtulungan nila si C para hindi makasali. Or kinall out nila si C for some reason na para huwag sumali sa contract. Or pinapa-withdraw nila. Diba? Sino-force nila ma-withdraw yung bid ni C. So, yun. That can be an offense under this law. Next would be when a bidder by himself or connivance with others employs schemes which tend to restrain the natural rivalry of the party. So, any other acts which tend to defeat competition, that is considered a criminal act under this provision. So for other, this is our fraudulent acts naman. So submission of eligibility documents of whatever kind that contain false information or falsified documents calculated to influence the outcome of the eligibility screening process or conceal such information in the eligibility requirements when the information will lead to a declaration of ineligibility from participating in competitive bidding. So dito, halimbawa, di ba, competitive bidding will require PhilJEP's Platinum membership. Di ba? Kung yung PhilJEP's Platinum membership niya, si bidder, alam niya, nag-expire na yung PhilJEP's Platinum, pero gusto niya sumali sa bidding na to. Kung ginawa niya, finalsify niya yung date ng validity ng kanyang PhilJEP's Platinum membership. So, finalsify niya. Tapos yun, sinabit niya pa rin. So, yun. So, paano nyo malalaman kung falsified ang yung mga PhilJEP's registration na yan? So, merong website ang PhilJEP's, excuse me, merong website ng PhilJEP's wherein you can verify the PhilJEP's registration. So, there. Yan. So, kung ba, verify nyo, wala naman pala siya. So, that can be considered a criminal offense under this for falsifying documents. Next would be submitting bidding documents of whatever kind in nature that contains false information or falsified documents. To conceal such information in the bidding documents in order to influence the outcome of competitive bidding. So ito parang pareho lang siya. Yung may false information. Another example would be, halimbawa, yung project natin is worth 1 million. So, ang SLCC natin should be at least, di ba, 50% of 50% of the ABC. So, ang SLCC natin is supposed to be 500,000. Si bidder, alam niyang 300,000 pa lang ang kanyang SLCC. 300,000 pa lang ang kanyang SLCC. He made it look. Finalsify niya, parang misrepresent niya na yung 300,000 na contract niya is 600,000. So, yan. So, para lang makaparticipate sa bidding. Diba? Yeah. That is one example. Next is using another's name or allowing another to use one's name. Yan. Dito, pwedeng maging liable ang gumamit at ang sakit, no? Ginamit ka na, napahamak ka pa. So, yung gumamit, siyempre, mapapahamak ka na. Yung ginamit, napahamak pa. Ang pangalan. Yan. Pwedeng ma-apply kasi yan sa pag-ibig, di ba? Yung ginamit at ang nagpagamit. Yan. So, ito example, usually may mga bidders na siguro meron kulang pa yung experience nila. Diba? To participate in a public bidding. Kulang pa. So, si bidder A, si bidder B, bidder B, pwede bang gamitin yung corporate ng para makapasok ka dito? Para infiltrate ko na yung government na yan. Government agency na yan, procurement nila. Para lang makaano ko. Si bidder B, sige, okay. Gamitin mo yung pangalan ko, yung mga SLCC ko, yung mga ganyan. Yeah. So, sino pwede maging liable dito? Paggamit, si bidder A and bidder B. Bidder A na gumamit ng pangalan ni bidder B, si bidder B na nagpagamit ng pangalan A, bidder A. Next would be withdrawal of a bid. Withdrawal of a bid after it shall been qualified as the lowest calculated bid or the highest rated bid, or refusing to accept an award without just cause or for the purpose of forcing the procuring entity to award the contract to another bidder. This shall include non-submission within prescribed time or delaying the submission of requirements such as but not limited to performance security preparatory to the final award of the contract. And yeah, so withdrawal of without justifiable cause. Laging natatandaan, without justifiable cause, yung kanyang withdrawal. So, we have our second knowledge check for today.
Yes, sir. We will be having our second knowledge check. So before reading the question po, may I remind our participants to please change your name format to LGU name _ your full name to verify your attendance by our event secretariat. So the question is non-submission or delay in submission of documents for the final awarding of contract considered automatically as withdrawal of bid? So is it A, yes, or B, no, must first be proven to be without justifiable cause? So again, is non-submission or delay in submission of documents for the final awarding of contract considered automatically as withdrawal of bid? Is it A, yes, or no, or B, no, must first be proven to be without justifiable cause? May we ask our participants to select your answer via the Zoom polling feature. So we will be closing the poll in 5, 4, 3, 2, and 1. So sir, most of our participants answered no, must first be proven to be without justifiable cause, 71% po.
Tama po ang majority ng ating mga participants. No, must be proven without justifiable cause. So, di ba, itatandaan yung delay in submission or delay in submission of documents does not necessarily constitute a criminal provision. But for delay, it must be without justifiable cause. Yeah.
Sir, let's proceed po.
Let's proceed na. Okay. Next, we have the civil liability. So, under the law, a judge, criminally liable, held criminally liable, is also considered civilly liable. So, ano yung mga, civil liabilities under the law? This is our restitution for damage done and forfeiture in the favor of the government of any unwarranted benefit derived from the act or acts in question at the discretion. So, first, restitution of damage, ito yung babayaran mo yung mga danyos na na-cause ng mga criminal acts mo. Yan, mga yung pag-fraud, yung pag-falsify ng mga documents, yan. Pangungurap, yan. Next would be forfeiture. Yung mga forfeiture, ibabalik naman sa government. Kung ano yung mga kinita mo, based on the judgment of the court, halimbawa, hindi angkop sa salary grade mo yung mga salary grade 15 ka tapos may nakakuha ka ng Ferrari dahil dun sa criminal acts mo, yung mga questioned acts, that may be forfeited upon the discretion of the courts. Kung determine ni court na hindi talaga angkop, yung na-derive mo dun sa unwarranted benefits. Dahil doon sa unwarranted benefits, by your actions, but your criminal actions. Next, we have administrative sanctions. So, ito yung mga suspension, blacklisting, forfeiture of bid security and for security, and disqualification. Kasi this is suspension already. So, yung first offense, 1 year, second offense, 2 years of participating in the public bidding process and the government. So we now go to liabilities under RA 3019. So are the anti-corrupt and corrupt practices. So we go directly to yung mga specific offenses under said laws. First would be persuading, inducing, influencing another public officer to 1A, perform an act constituting the violation of the rules. B, allowing himself to be persuaded, induced, or influenced to commit such violation. So, knowledge check na kagad tayo. Ano ang Tagalog ng persuading? So, dapat sa knowledge check na. Ano ang Tagalog ng persuading? So, sagot dyan in 5, 4, 3, 2, 1. Tamang sagot, ang Tagalog ng persuading ay unang kasal. Yan. Yan ang matatandaan nyo sa lecture ko ngayon. Ang joke. Yan marami akong sinabi. Huwag lang yan ang tandaan nyo. So, persuading, dito sa provision na to, if you remember kanina, yung nang-induce na boss ni back member. Diba? So, dito, sa RA under the IRR of RA 918 for yung procurement law natin, criminal provisions under procurement law, ang magiging liable doon is yung nag-influence, yung nag-exert ng undue influence kay back member. Pero under this law, diba, as we can see, yung mga nagpa-persuade, yung mga na-influence. So yung nag-exert ng undue influence at yung na-influence, pwede maging liable. So kung liable na sa RA 9184, ang liable lang yung nag-exert ng undue influence. Sa RA 3019, yung nag-persuade at yung na-persuade. Diba? Hindi yung nakasala, yung na-persuade, na hikaya. Yan. So a person allowed himself to be persuaded, induced, or influenced to commit such violation or offense. So this provision parang emphasizes that back members should not in any way allow themselves to be pressured or influenced in any way, and that they should perform their functions based on the mandates of the law and the dictates of good conscience. Diba? Dapat mga procurement practitioners natin, not only back members, mga secretariat, mga TWG, they should always be independent minded. Diba? Decide based on their good conscience. Diba? Not on the influence of others. Mga nagbigay, yung mga nagpe-pressure. May nag-pressure man. Next, criminal provisions are under RA 3019 would be section 3B, directly or indirectly requesting or receiving any gift, present, share, percentage, or benefit for himself or for any other person in connection with any contract or transaction between the government and any other party, and the public officer in his official capacity has to intervene under the law. Yeah. siguro pag-aaral namin ng law, when we go to specific specific provisions, specific offenses, we dissect it, we look at the elements. So let's look at the elements of this provision. So how may this be committed? Directly requesting, indirectly requesting, or receiving any gift, present, share, percentage, or benefit for himself or for any other person. Yan ang first. So first element natin, there are 3 ways to commit this provision: directly or requesting, indirectly requesting, or receiving. Yan. So second element would be in connection with any contract or transaction between the government or any other party. Third element, wherein the public officer in his official capacity has to intervene under the law. Yan. So dito, dahil walang takas, so yung directly, yung nangingi ka, baka namang meron tayo dyan. Yung sinabi na mismo, di ba? Indirectly, yung mga Buchanan meron dyan. Yan. Pag or receiving, hindi mo pwede sabihin, ay, dumating lang yan. Ay, hindi ko naman hinihingi eh. Binigay lang sa akin. Hindi, tinanggap ko. Yan. Yan yung mga provisions. Mga ways to commit the said crime. Next would be accepting or having any member of his family accept employment in a private enterprise which has pending official business with him during the pendency thereof within 1 year after its termination. So, halimbawa, merong pending transaction, infrastructure project, big engineering company, big construction company. Si back member, may anak siyang engineer. So, yung anak ng engineer gustong big construction company. So, it was considered there. So, actually, this is a difficult provision to prove. So, pero it all parang walang conflict of interest. Kumbaga, nga. So, diba, kahit gusto ng anak niya na mga employee doon sa malaking construction company na may transaction doon sa government agency we're in, his parent is a back member, he cannot accept such employment. So, can only accept kung gusto niya talaga doon, can wait after 1 year, after the termination of the project. Diba? So, kung ba 3 years yung project niya, tapos 3 years yung construction, 4 years na maghihintay para magpa-transaction. In order not for this provision to be not applicable. Next would be causing undue injury to any party, including the government, giving any party, private party, any unwarranted benefits, advantage, or preference in the discharge of his official, administrative, or judicial functions through manifest partial, evident bad faith, or gross inexcusable negligence. This is so. Ito, halimbawa, merong pre-prefer na bidder. Yan. So, kasi sa may ganyan, mayroong mga preferred supplier. Tama. Preferred supplier. Tama. Diba? So, dapat all bids should be treated on equal footing. Diba? Kahit alam mong okay to, alam mong magaling to, hindi pwedeng dahil alam mo lang magaling to, di-disregard mo na lahat. I-exapwera mo na lahat, i-disqualify mo na lahat. So, binigyan, kahit kulang ang documents niya, pinalabas mong kompleto. Yan, that is one example of this provision. kahit overpriced yung contract, kinukuha mo pa rin. Yan. Next would be entering on behalf of the government into any contract or transaction manifestly and grossly disadvantageous to the same, whether or not the public officer profited or will profit thereby. Ito, bawat contract na sobrang disadvantageous. Alam nyo nang hindi siya pasok. Mga computers, pinocure nyo pa rin, kahit Pentium 4, na ngayon, parang mga system ngayon, sobrang Intel Core i5, mga 7th gen na. Tapos Pentium 4 ang mo. So, yan. So, this, if you enter into a contract which is grossly disadvantageous to the government, it doesn't matter whether or not you profited or not. Whether or not you profited in the said transaction. So, basta mere entering into a contract which is manifestly and grossly disadvantageous to the government. That is considered a provision, violation under this. Applicable penalty rin dito sa RA 301, imprisonment of not less than 6 years and 1 day, not more than 15 years. It's also considered. It includes perpetual disqualification from office and confiscation or forfeiture in favor of government. We now go to the protest mechanism found under RA 9184. These are the remedies of the bidder on any decisions of the bank during the procurement stage. Yeah. So, during opening of bids, na-disqualify si bidder. So, bidder has 3 calendar days upon receipt of the written notice of upon verbal notification of his disqualification. So, first, you have to take into consideration when counting days, kung yan mga ganyan, 3 calendar days, 7 calendar days, 12 calendar days. Yeah. And we count periods, lagi nating tatandaan ang kantang Feli Nympha ang pangalan ng issuers. Bakit yun? Tandaan nyo, first day excluded, last day included. So, first day excluded, last day included. So, Feli, di ba? Si Aling Feli. So, using that principle, first day excluded. So, halimbawa, ngayon disqualify si bidder A. So, ngayon niya rin na-receive yung notice of his disqualification. Ngayon siya na-inform na disqualified siya. He has 3 calendar days within which to file. So, today is the 26th. So that, using the Feli principle, first day excluded, so we count starting 27, 28, 29. Yes, until November 29 to file his request for reconsideration. Yeah. After which, so si BAC ngayon magde-decide within 7 calendar days from receipt of the request for reconsideration. Halimbawa, under our example, as until the 29th, nag-submit siya ng 29. Na-receive ni BAC nung 29 din mismo. So until 7 calendar days within which to reply, to decide upon the request for reconsideration of bidder A. So 29 niya na-receive. So first day excluded. So we start November 30, December 1. Wow, December na. December 1, December 2, December 3, 4, 5. That's until December 6. the bank has until December 6 to decide on the request for reconsideration. So, nag-file siya ng request for reconsideration. So, kung denied yung request for reconsideration niya, only then can the bidder file a protest in writing to the hope. So, lagi natin tatandaan ba, hindi pwedeng rumekta si bidder kay hope kagad for request for protest. Dapat meron pa siyang request for reconsideration muna. So, pag denied ang request for reconsideration, only then can the bidder file his protest before the hope. So ano yung ito yung mga requisites. So dapat parang bago siya makapag-file ng protest before the hope, dapat merong prior request for reconsideration properly filed within 3 calendar days and decided upon by the BAC and denied by the BAC. So, granting, yan, nag-file siya ng request for reconsideration within 3 calendar days, tapos dininay ni BAC, tapos ngayon magpa-file na nga siya, pwede na siya mag-file ng protest before the hope. Yeah. So, before we discuss, what are the requisites for filing a protest? So, protest must be in writing through a verified possession paper, a payment of a non-refundable protest fee to be paid in cash, and the certificate against forum shopping. This is addressed to the hope and filed within 7 calendar days from receipt of the decision of the BAC denying the request for reconsideration. So, bitin tong makatago lang yan. Imagine nyo na, filed within 7 calendar days from receipt of the decision of the BAC denying the request for reconsideration. So, yeah. So, na-receive ni bidder A yung notice of denial of the request for reconsideration without another 7 calendar days wherein he can file a protest before the hope. So, verified possession paper with certification against forum shopping. So, ano ba tong forum shopping? So, ang naiintindihan lang natin ay shopping, di ba? Kasi malapit na magpasko, yan. Christmas shopping. Pero itong forum shopping, ito yung practices ng mga litigants na mag-file ng multiple actions in different tribunals. So, nag-file siya dito sa court, sa RTC, sa Court of Appeals, sa Sandigan Bayan, halimbawa. Yan, nag-file siya. Ganyan. Iba-iba. Para kung sino yung pwede sa kanya, yun yung ano niya. So that is allowed. That's not allowed, actually. So kaya may certificate against forum shopping. Kailangan ito in state ng affiant nung nag-file ng protest na he has not filed any action involving the same issues in any tribunal, court, or quasi-judicial body. Yeah. Next, ano itong verified possession paper? So, ano yung contents ng verified possession paper? First, the bidder's name and address, name of project, implementing office or procuring entity, brief statement of facts, issues to be resolved, other matters and information pertinent and relevant to the proper resolution of the protest. When we say verify, the position is position papers verified with affidavit yan, kasama yan ng halimbawa, position paper, meron separate affidavit na verification and certification against forum shopping. Yan yung contents nung, ayun yung state niya na sa verification na the client was understood and read the contents thereof and the allegations are true and correct of his personal knowledge and based on authentic records. So kung yung possession paper mo is unverified, it will be considered unsigned and loses no effects, no legal effects, and results to the outright dismissal. So di ba, yes, 7 calendar days. Kung halimbawa, on the 7th day, siya nag-file ng possession paper pero hindi siya verified, it will be dismissed. Does he have fresh period? Can he still file a verified possession paper? No. Kasi tapos na yung period. Next fail, yung he cannot parang cure the said defect by mere amendment of the verified possession paper. Basta na-receive nyo unverified possession paper, dismissed na yan. Considered unsigned pleading yan. And produces no legal effects. So there, granting, denied, request for consideration, denied by the bank. So na-receive niya ngayon ang notice of denied request for consideration. So he has 7 calendar days to file his protest. So before the hope. So ano yung format? Siyempre kailangan verified possession paper and merong payment of a non-refundable protest fee. Bakit may protest fee? Kasi this is to weed out yung mga bidders na nagpo-protest na masabi lang na mag-protest. To delay the bidding procedures, the procurement process. Kasi kahit na ng example ko, kahit na mag-request for reconsideration yung disqualified bidder, tuloy-tuloy lang ang bidding process natin. Hindi lang siya mag-award. So, kailangan, before ma-award, resolve na ang protest natin. Resolve na ang request for reconsideration natin bago ma-award. So, kung hindi pa na-award, kung hindi pa na-resolve, hindi mo na mag-award. Diba? So, granting, nag-file na siya ng protest within 7 calendar days, possession paper, bayad siya ng non-refundable protest fee. Si Hope shall resolve the protest within 7 calendar days from receipt. And the head of BACSEC shall furnish the bidder with a copy of the decision within 7 calendar days from receipt. So kailan tayo magre-resort to regular? Halimbawa, pwede ba siyang tumuloy mismo sa court? Hindi. It will, under the doctrine of exhaustion of administrative remedies, merong remedies na provided for under the law. Diba? So under that doctrine, before you resort to court action, dapat na exercise mo muna yung remedies mo under the law. You've exhausted the necessary remedies under the law. So, kung ba pinilit pa rin niya, hindi siya nag-file ng protest fee, final pa rin niya sa korte, that can be dismissed, outrightly dismissed. Kung halimbawa naman, compliant siya, file siya ng request for registration, denied ng back, file siya ng protest before the Hope, with payment, verified possession paper, payment of non-refundable protest fee, denied pa rin ni Hope. So, then you can file only then can he file a court action via RTC under certiorari under Rule 65. So ito ang ating range ng protest fees. 50 million pesos na below 0.75 of the EBC. More than 5 billion pesos yung project nyo. 0.1% of EBC. And that brings us to our third knowledge check.
At this point, we will be having our third and last knowledge check for the first session for today. So may we ask our participants to select their answer via the Zoom polling feature. The question is, the non-payment of the protest fee does not toll the prescriptive period for filing a protest, and it becomes a justifiable basis for the Hope not to entertain a protest. Is it A, true, or B, false? Again, the non-payment of the protest fee does not toll the prescriptive period filing a protest, and it becomes a justifiable basis for the Hope not to entertain a protest. Is it true or false? Our Facebook Live viewers may also type in their answer by the comment section. So we will be closing the poll in 5, 4, 3, 2, and 1. So most of our participants answered true, 90%, while the other 10% answered false.
Sagot dyan ay true. Galing ha? Majority answered it correctly. When we say does not toll, tuloy-tuloy lang. Hindi niya masuspend yung period. Diba? Pag nag-file siya ng protest fee, hindi siya nagbayad ng... pag nag-file siya ng protest, hindi siya nagbayad, tuloy-tuloy lang yung 7 calendar days. Diba? Very good. Galing, 90% of our participants answered correctly. So,
and that ends the first part of our session for today. Thank you so much, Attorney Atis, for facilitating a comprehensive lecture on protest mechanisms and remedies. At this point, we'll be having a short break, and after the break, our resource speaker will join us again for our second part of the session. So may we remind our participants to please be back after 10 minutes. Please take this time to accomplish the general evaluation of presentation materials, and resource speaker for days 1 to 4, which is a requirement for the issuance of the certificate of completion. So please be back at exactly 9:39. Gawin na nating 9:40. Ayun. Thank you.
Have you ever wondered how sharing of issued blacklisting orders could be made easier for your agency? Well, with the Online Blacklisting Portal, or OBP, you are only one click away from posting and updating the status of your blacklisted entities and accessing information related to your agency's blacklisting history. Let me give you a quick walkthrough of the new OBP. To register, visit the link flashed on your screen. One registration per PE is allowed, and only the official user can request for registration. After the successful registration, an alternate user can be added. Your registration will be validated upon receipt of the documents flashed on your screen. Within 3 days from the effectivity date of the BO, PEs should be able to post the BO by filling out the form in the OBP and uploading the copy of the approved BO. You can simply click on the Update Status tab from the Blacklisting Order Details screen. In case you need to change or update your account details, you may send a request to the email address flashed on your screen. For more details, you may visit the OBP homepage to access these files.
Do you know that procurement is crucial in achieving our society's collective vision of a strongly rooted, comfortable, and secure life in the Philippines? Hello everyone, I'm Billy Bayong. Let me show you how our Procurement Policy Board innovates, adapts, and responds to our changing needs to enhance the procurement system and help the government work for us. An efficient, transparent, and competitive procurement system connects every Filipino to vital services from the government. This can help move more people out of poverty, gain access to better education, receive quality healthcare, and enjoy economic opportunities. These yield greater trust in government institutions and bring the country closer to achieving its national development goals. The Government Procurement Policy Board focuses on simplifying various processes to produce more successful procurement that contributes to the effectiveness and efficiency of the government. The board employs strategies to identify needs and implement projects. It refines and calibrates procurement policies, adjusting to emerging trends based on needs of procuring entities. It creates ways to capacitate practitioners to better manage their procurement processes, monitor effectiveness of our procurement systems, and it adapts to the times, especially during national emergencies. The GPPB has strengthened the procurement process at the earliest stage, the planning phase. The board has issued bidding rules responsive to new laws and policies set by the government. GPPB has also streamlined the bidding process through the use of technology. GPPB has introduced guidelines to ensure timely procurement, especially during a national emergency. GPPB Technical Support Office pioneered initiatives to better assist procuring entities. Simple and competitive, transparent and accountable, monitored by the people. These make for an effective procurement system, responsive to the needs of the people. The GPPB, adapting, responding, innovating for nation building. To know more about procurement, visit gppb.gov.ph.
Barely 2 months into 2020, and as countries grapple to contain the coronavirus pandemic, we saw an unprecedented disruption of the global supply chain, with most countries implementing varying levels of lockdown and quarantine measures. Manufacturers and suppliers had very limited operations, with their raw materials and supply source unable to reach their factories and shops, with a temporary embargo on freight and logistics. In some cases, for the first time, to procure personal protective equipment and related supplies. What used to be a procurement project undertaken by hospitals and allied medical offices is now trusted upon most government procurement practitioners. This poses a huge risk to the quality of procurement as procuring entities scramble to buy in large quantities in the fastest time possible, but with asymmetrical or limited market information. Moreover, with the community quarantine being imposed in most parts of the country, particularly in urban areas, a number of prospective bidders were unable to physically submit or attend pre-bid conference and opening of bids, resulting in a number of cancelled or even failed biddings. And with telecommuting being implemented in most government agencies, the conduct of procurement activities was made even more challenging given the unreliable internet connection, traditional paper-based records keeping, and with some official documents requiring handwritten signatures for processing, all of which compounded the already difficult and complex work of government procurement practitioners. Emergency procurement in times of crisis inevitably opens door for inefficient acquisitions by people under severe time pressure, for some unintentionally but others occurring as a result of corruption. As we have seen other countries struggle in the response to the pandemic, the Philippines, through the Government Procurement Policy Board Technical Support Office, foresaw the need to anticipate procurement constraints given the grave and possibly prolonged effects of the coronavirus pandemic. As early as March 9, 2020, the GPPB met and issued Resolution Number 03-2020 adopting efficient, effective, and expedient procurement procedures during a state of public health emergency. As shown here, negotiated procurement under emergency cases can now be undertaken with 4 simple steps. This was made possible with the streamlining of the existing procedure being undertaken. Thus, the rules now dispense with the requirement of a written confirmation from the head of the procuring entity of the existence and veracity of the grounds relied upon. The board likewise expressly included the instances or situations where emergency procurement may be applied, such as the provision of immediate response and initial recovery steps to avoid loss of life, injury, disease, and other negative effects on human physical, mental, and social well-being, together with damage to property, destruction of assets, loss of services, social and economic disruption, and environmental degradation, as well as the lease of real property or venue for use as quarantine centers, evacuation sites, medical relief and aid distribution, locations, warehousing facilities, or similar temporary disaster or emergency response facility. This enabled procuring entities to readily adopt emergency procurement for the purchase of COVID-19 related items. Upon upon the declaration of a state of public health emergency by the President, the GPPB Technical Support Office immediately coordinated with the Department of Health and the Procurement Service to identify items that will be needed by most agencies so they can be included in the list of common use supplies and equipment which the Procurement Service can buy in bulk and take advantage of economies of scale. This includes alcohol, sanitizers, thermometers, personal protective equipment, gloves, mask testing kits, among others. Agencies can then readily purchase these items from the procurement service when available, giving them more time to focus on other equally important tasks. And when Congress passed the Bayanihan to Heal as One Act, the GPPB immediately issued the Bayanihan procurement rules, which included a provision on direct purchase from local farmers. The board likewise simplified the documentary requirements for this modality. Accordingly, procuring entities intending to directly buy from a local farmer need only to ask a submission of any of the following: a certification from the Department of Agriculture that the farmer is in the registry system for basic sectors in agriculture, or RSBSA, or his RSBSA identification card.
We welcome again our resource speaker, Attorney Atis from the Department of Justice, to discuss the blacklisting guidelines for the second part of our session. Nakamute po ata kayo, sir.
Concludes my discussion for today. Joke. Sorry. Okay, sorry.
Once again, we give the virtual floor to Attorney Atis.
Okay. We'll now continue our discussion on our second module for the day. So, discussing the blacklisting guidelines found under this law, under RA 9184. First, the module objectives. By the end of this module, participants should be able to understand the procedures and imposing, administrative sanctions in the form of blacklisting to bidders who committed any of the violations during the competitive bidding or the contract implementation stage. So, dito, ma-determine natin yung difference ng blacklisting during competitive bidding or the procurement stage, and the blacklisting during contract implementation stage. Also, to gain substantial knowledge on the responsibilities of the back secretariat, observers, bidders, and end users or implementing units relative to the issuance and posting of the blacklisting order. So, this is the outline of our discussion today. First, we discuss the uniform guidelines. Next, the blacklisting procedure during procurement stage, and the blacklisting procedure during contract implementation stage. So, there's actually a difference in the process and actually on who will initiate the blacklisting. Diba? May difference sila. So, first we go to the uniform guidelines. So, this guidelines is found under GPPB Resolution 40-2017, effective September 4, 2018. Next, we have GPPB Resolution 14-2020, which was made effective August 7, 2020. First, we go to definition of terms. What is blacklisting? Blacklisting is an administrative penalty disqualifying a person or an entity from participating in any government procurement for a given period. So, any government procurement. So, blacklist siya, hindi na siya pwedeng mag-participate kahit saang government agency. Diba? Difference yan. Nakikita niyo sa susunod na. So, blacklisted person. Who is the blacklisted person or entity? A person or entity was disqualified by an agency and or is included in the GPPB Consolidated Blacklisting Report. Yeah. Blacklisted, meron tayong GPPB Blacklisting Report. So, we now go to suspension. Yan. You'll encounter blacklisting and suspension minsan pag sunod. So suspension, on the other hand, is an interim penalty imposed for infractions committed by a bidder during the procurement stage. Yan na. Whereby such bidder is prohibited from further participation in any of the bidding process of an agency. Yan. So pag nasuspend ang isang bidder, hindi na siya pwedeng mag-participate dahil interim penalty. Hindi na siya pwedeng mag-participate in any bidding process of the said agency na nag-suspend siya. Kung halimbawa, nasuspend siya sa DOJ, pwede pa ba siya mag-participate sa DFA, sa DOH? Pwede pa naman. For as long as suspended pa lang siya. Yeah. Suspension also shall be effective during the period of motion for reconsideration and or appeal and shall terminate only upon final decision by the Hope or the appellate authority. Yeah. So, once na-suspend siya, kahit nag-MR siya, nag-appeal, effective pa rin. Unless na-reverse ni Hope or the appellate authority ang decision to suspend. So, tandaan nyo, yung suspension is only applicable during the procurement stage. So, appellate authority, so the department, this is the department or office or local or government unit exercising general and or administrative supervision or control over the blacklisting agency. So, department level agencies shall exercise appellate authority over the offices, agencies, bureaus, government units, GOCCs, and SECs under their jurisdiction. So, blacklisting decisions of agencies that are not subject to general and or administrative supervision, so control or supervision of any department, office, government unit shall be final and executory. So, in your case, yung mga local government units, kung yung mga appellate authority nyo is yung provincial government. Yeah. The listing. This is the removal of a person or entity from the consolidated blacklisting report. So, dito, automatic ito. From nag-lapse na yung penalty, yung 1 year, nag-lapse na. Automatic, madedelist na sila. Mawawala na sila dun sa consolidated blacklisting report. Kasi before, kasi may discuss ako before, yung bago ma-delist, kahit patapos na yung period niya, nag-elapse na yung period for blacklisting niya, parang the GPPB asks the procuring entity kung i-extend pa siya. Di ba? Ngayon, automatic na. Kung 1 year yung blacklisting niya, 1 year. Kung November, kung sinasabi ng November 25 to 2021 to November 25, 2022 ang term ang yung ang blacklisting mo. So 1 year. after November 25, 2022, after nun, automatically delisted ka na. Sino ang covered ng blacklisting? So this covers for individuals and sole proprietorships, bidders and spouses, for partnerships in partnership itself and its partners. For cooperatives, yung cooperatives mismo, members of the board of directors, yung general manager, and chief executive officer. Yung partnership, joint venture, or consortium yung na blacklist or has blacklisted members and or partners, as well as who is member of a blacklisted joint venture or consortium. So yung ngayon ang the blacklist, lahat ng kasama doon sa joint venture consortium blacklisted din. Corporation, single stockholder, together with his relatives of the third civil degree of consanguinity or affinity, and their assignees holding at least 20% of the shares therein. Its chairman and the president. Let's check agad. So, ma'am, this brings us to our first knowledge check. This is true or false. Janelle, ano po ang ating question sa knowledge check?
At this point, we will be having our first knowledge check for this session. So may we please ask the Secretariat to please. So the question is, blacklisting is an interim penalty imposed for infractions committed by a contractor during competitive bidding stage, whereby such contractor is prohibited from further participation in the bidding process of an agency. Is it A, true, or B, false? Again po, blacklisting is an interim penalty imposed for infractions committed by a contractor during competitive bidding stage, whereby such contractor is prohibited from further participation in the bidding process of an agency. Is it true or false? Please select your answer po in our Zoom polling feature. We will be closing the polling feature po in 5, 4, 3, 2, and 1. So most of the participants answered true, 81% po sir, and yung false po, 19%.
Ang tamang sagot ay false. Yan. Tingnan nyo mabuti, di ba? May slide ako, in-explain ko yung blacklisting and suspension. This is actually suspension. Yan. So, madaming na mali, madaming na dito. Di ba? Suspension is an interim penalty imposed for infractions committed by a contractor during the competitive bidding stage, whereby such contractor is prohibited from further participation in the bidding process of an agency. Diba? Meron tayong slide dyan. May separate slide dyan. Binasa ko line per line. So, bale. Okay lang yan. May mga, sabi nga sa true or false ng ating professor, chamba-chamba lang yan. Diba? So,
please note na lang po the answer for this question and bawi po tayo sa susunod na knowledge check.
bawi
So,
tayo.
sir?
Yes. Okay. So, proceed. now go to the blacklisting, grounds blacklisting during procurement stage. Yan. Diba? Sabi ko kanina, blacklisting, meron tayong blacklisting during competitive bidding or procurement stage at blacklisting during contract implementation stage. Yan. So first, siyempre we discuss blacklisting during procurement stage. So basically, yung mga grounds for blacklisting during procurement stage, this is also discuss natin criminal provisions in submission of eligibility requirements containing false information or falsified documents. Diba yan yung sabi kanina yung SLCC, 300,000 lang, tapos ang project natin is 1 million. So ang SLCC natin is 500,000. Pero ang sinubmit ni bidder made it appear na yung SLCC na 300,000 to look he misrepresented for his single largest completed contract of 300,000 to make it look more than the 50% of the EBC. So pinano ng 600,000. So yun, that can be considered the ground for blacklisting. Paano nyo na na-verify ito? Na-verify nyo ito during kaya tayo may post-qualification. This is the stage wherein we verify the documents. So yung falsified documents, yung nga, sinabi ko kanina, yung PhilJEPS registration. You can verify it on the PhilJEPS email. Meron yan yung parang meron dyan open data. Kung i-enter nyo yung number na sinubmit nila, doon lalabas yung details. Kung valid ba yung yung PhilJEPS registration number. Yan. Submission of bid documents containing false information or falsified documents or of such information in the bids in order to influence, and same lang siya dun sa taas. Also, refusal to clarify or validate with writing its bid during the post-qualification within the period of 7 calendar days from receipt of the request for clarification. Yan. Parang nagpo-post-qual na, syempre merong, siguro, si BAC meron siya din maintindihan, or si TWG. So, he asks yung bidder, parang clarify lang in writing. So, hindi siya nag-reply. That can be a ground for blacklisting during contract procurement stage. During the procurement stage. Any documented, unsolicited attempt by a bidder to unduly influence the outcome of the bidding in his favor. Yan yung mga bibigay. Yan, document, unsolicited attempt. Hindi ka nang hingi, pero bigla siya bibigay para to influence yung mga papakain. Yan. Papakain during the public bidding. Siyempre, hindi dapat. Also, one ground would be allowing the use of one's name or using the name of another for the purpose of public bidding. Yeah. That can be considered that can be a ground, also a ground for blacklisting during the procurement stage. Withdrawal of a bid or refusal to accept an award or enter into a contract without justifiable cause after he had been adjudged, having submitted the lowest calculated responsive bid or highest rated responsibility for consultants. So dito, nag-ano na siya ng process, undergo na ng process, tapos yung i-award niya, ayaw niyang tanggapin. Sabi niya, tapos without reason lang. Kasi wala lang, ayaw na namin tanggapin. Yeah, that can be a ground for blacklisting during complaint. Refusal to post the required performance security within the prescribed time. So yung performance security should be posted, di ba, within 10 days from the issuance of the notice of award and calendar days. So after after nyan, hindi siya that can be a ground for blacklisting. All other acts which tend to defeat the purpose of competitive bidding, such as habitually withdrawing from biddings or submitting late bids, or patently insufficient bid for at least 3 times within a year, except for valid reasons. Ang ano dito, except for valid reasons. Wala siyang valid reason at yung mga nag-withdraw siya for 3 times. Pero nangyari ganyan sa amin, sa mga computers, parang pa-participate siya, tapos lagi siyang late. So, explain naman namin, may valid reason naman siya kung ba't siya na-delete or nag-withdraw. Kaya hindi siya na blacklist. So, mga sanctions for blacklisting during procurement stage. So, siyempre, bid security for feature. Kung blacklist siya 1 year, first offense, 2 years for the second offense, enforcement of the bid security case in bid security, yung bid security na. Without prejudice to the imposition of additional administrative sanctions, the internal rules of the agency may provide and or further criminal prosecution. Di ba yung mga grounds natin for criminal acts, meron din dito. So, alam natin yung grounds. For criminal act, pwede rin natin i-blacklist siya. So, this is the flow chart. Okay? We're now discussing the process ng ating blacklisting during procurement stage. So, first, who may initiate the action? So, any bidder, or prospective bidder, duly authorized observer, or SIBAC. We take note for the purpose of this discussion, contractors shall refer to manufacturers, suppliers, distributors, contractors, and consultants. Yeah. So, who may initiate, si BAC, again, si BAC, si duly authorized server, or any bidder or prospective bidder. Next, so first, siyempre, under our constitution, there we have the due process clause, di ba? So, siyempre, we have to inform the person of the nature of the causes of the accusation against him. Here, compliance with the due process clause, we notify the contractor in writing upon verification of the existence of the grounds, mga grounds mentioned earlier. So, the notice shall contain the following. So, yes, you'll be informed that the complaint has been filed. It's the opportunity to show cause, to explain that the hearing shall be conducted upon request. So, upon his request, pwedeng yung hearing naman, parang short hearing naman siya, hindi siya adversarial. Parang court din siya. Parang ano lang siya, summary hearing lang siya. Consequence, you'll be informed of the consequence of being suspended and blacklisted. Next, the contractor shall submit, kung na-notify na siya, contractor shall submit his written answer to the BAC with documentary evidence and request for hearing if he so desires within 5 calendar days from receipt of the notification. So, no time extension shall be allowed. So, notice, when you na-receive, count 5 calendar days, 27, 28, 29, 30. It's until December 1 to file his answer to the notice of blacklisting. So, ito. Halimbawa, hindi siya nag-submit ng answer in 5 calendar days. So, lumipas ang 5 araw, wala siyang sagot. Hindi niya sinagutan. Or nag-lapse lang. Or nag-file siya pero hindi pasok. The BAC now recommends to the HOPE suspension of the contractor and the feature of the bid security. So, i-recommend na yun ni BAC yung suspension na kasi hindi naman siya nag-file na answer. So, si HOPE ngayon, within 15 calendar days from receipt of the BAC resolution and records of the BAC proceeding, determine niya whether or not there is reasonable cause to suspend the contractor. Kung wala siya makitang reason, if no, the case will be dismissed. If yes, the Hope issues the suspension order and forfeiture of the bid security. Simple lang. Hindi siya nagsagot. File na recommendation si BAC kay Hope for suspension. Determine na ni Hope yung existence of reasonable cause. Kung meron, mag-issue na suspension order. Kung wala, dismiss case. Paano kung nag-submit siya ng answer na pasok within 5 calendar days? Pasok siya within 5 calendar days. Titignan natin kung may request for hearing. Kung may request for hearing, magpapandak kagad ng hearing ng PAC. So, these are parang summary hearing lang. Set kagad, date and time, tapos determine existence of fault. Yan. I-determine na ngayon ni BAC existence of fault. Based on the complaint, answer, and documentary and facts verified. Kung nag-request for hearing, di naman siya nag-request for hearing, magre-decide na kagad si BAC on the existence of fault. Based dun pa rin. Sa complaint, answer, documentary evidence, and facts verified. Kung meron existence of fault, okay. Yeah. So, may na-determine ni BAC na may existence of fault, the BAC can recommend ngayon to the Hope suspension of the contractor and the forfeiture of the bid security to the Hope. So, recommend siya kay Hope. So, Hope, again, as 15 calendar days from receipt of the BAC resolution to determine the existence of a reasonable kung meron, suspension order and forfeiture of security. Kung wala, dismiss the case. So, kung halimbawa nag-decide na suspend, kung yes, di ba? Nag-issue na ng suspension order si Hope kay contractor. Hope shall furnish the suspended contractor a copy of the decision immediately after its publication. So, ano effect ng decision? So, upon receipt of the notice of decision, suspended na sa contractor. So, hindi na siya pwede mag-participate sa bidding process of the agency which issued the suspension. The agency which issued the suspension. Agency lang. So, agency pa lang. Suspended pa lang siya. The suspension shall remain in effect during the period of motion for consideration and appeal and shall terminate only upon reversal of the decision by the Hope or appellate authority. Yeah. If no motion for consideration or appeal is filed, the decision shall become final and executory upon 7 calendar days. After 7 calendar days from the receipt of the notice of the decision, and the Hope shall issue a blacklisting order. Halimbawa, ngayon na-receive ni contractor yung decision to suspend. So, hindi siya nag-file ng MR, hindi siya nag-file ng appeal. So, after 7 calendar days from his receipt, mag-i-issue na ngayon ng blacklisting order si Hope against the contractor. So, may blacklisting na, hindi na siya pwede mag-participate in any procurement agency of the government, of the whole government. So, yun yung makikita yung distinction between suspension and blacklisting. So, suspension, parang preventive suspension lang siya. Until yung final and executory, only then, gagawin blacklisting yan. What if nag-file ng motion for reconsideration and appeal? So, if nag-file ng MR si contractor kay Hope within 3 calendar days based on the decision does not conform with the evidence or fact or newly discovered evidence. Wherein the hope resolves the MR within 7 calendar days. But if denied, kung halimbawa denied yung MR niya, we can file an appeal. So appellate authority. So kung denied pa rin, kung hindi siya nag-file ng appeal, mag-i-issue na ng blacklisting order after 7 calendar days. Si Hope. Kung nag-file naman siya ng appeal, the appellate authority resolves the appeal within 7 calendar days. And pag hindi siya granted yung appeal, mag-i-issue ng blacklisting order. Si Hope. And we have our second knowledge check.
Yes po, at this point, for the most awaited part, we will be having our knowledge check. May we ask our participants to type in their answer via the Zoom chat box. The GPPB TSO will give another special token to the first participants who will answer the question correctly. The question is, may a PE conduct necessary modification of the posted blacklisting orders? Is it yes or no? Again, may a procuring entity conduct necessary modification of the posted blacklisting order? Is it A, yes, or B, no? While our technical team is validating the winner for this knowledge check question, please be informed that we check the evaluation on general and presentation evaluation, and most of our participants have not yet answered those evaluation forms. So please answer it so that you can receive a certificate of completion. So do we have a winner na po? Okay, sir. May we ask Attorney Atis po the correct answer first?
Ang answer dito is yes.
Yes, ayun po. So
majority of the people answered yes. And so online blacklisting portal allows us as the designated user to modify kasi minsan yung mga orders or to lift yung blacklisting. So pwede na i-lift para may mga TRO na 15 days. So yung blacklisting order would be lifted for 15 days. So yeah.
pwede po. Ibig sabihin, pwede pa po tayong mag-modify after posting of blacklisting order. So, the winner for our knowledge check for today, for the last knowledge check with prize, is from LGU Quirino, Miss Perlita Iwag Diligen. She answered A, true. So, congratulations po, ma'am. Our event secretariat will coordinate with you on how you may claim your token. So, I will give the virtual floor again to Attorney Atis.
Okay, so continue. So now go to the blacklisting during contract implementation stage. Kanina, blacklisting during procurement stage. So here we have blacklisting during contract implementation stage. So we have the grounds for blacklisting during failure of the contractor due solely to his fault or negligence to mobilize start work or performance within the specified period in the notice to proceed. So, dito, for this to be a ground, for this to be considered a ground, dapat yung failure na to mobilize is due solely to the fault or negligence ni contractor. Diba? Dapat si contractor lang ang may fault or negligence. Pero kung may factor din si procuring entity doon sa failure to mobilize, kung meron din silang fault or negligence on this failure to mobilize, that can be considered a ground for blacklisting. Next would be failure by the contractor to fully and faithfully comply with its contractual obligations without valid cause, or without valid cause, or failure by the contractor to comply with any written lawful instruction of the procuring entity or its representatives pursuant to the implementation of the contract. So dito, diba, under the law, the contract is the law between its parties. So dapat it should be complied faithfully, diba? Fully and faithfully, diba? Kung hindi si contractor hindi niya na-comply yung completely yung contract niya without valid cause, that can be considered a blacklisting during. Kasi yung kontrata na yung kontrata na between the procuring entity and the contractor. So, dapat kino-comply na yan. Nag-implement na tayo. Also, failure by the contractor to comply with any written lawful instruction of the procuring entity or its representatives pursuant to the implementation of contract. So, siyempre, may mga instructions minsan si procuring entity to do something based on the contract, but sa lawful instruction, hindi niya comply, that can be considered blacklisting. Next would be assignment and subcontracting of the contract or any part thereof, or substitution of key personnel named in the proposal without prior written approval by the procuring entity. Ito, as a general rule, subcontracting, this pertains to subcontracting, which is not allowed. So, general rule, subcontracting is not allowed. Except, however, there's a prior written approval of the procuring entity. So dito rin, so yung this also covers yung sa procurement of consultants, yung substitution of key personnel, dapat rin ini-inform bago mag-substitute yung mga sa contract for consultancy, bidding for consultancy, bago mag-substitute of key personnel, dapat may prior written approval si procuring entity. Next would be for procurement of goods, unsatisfactory progress in the delivery of goods by the manufacturer, supplier, or distributor arising from his fault or negligence, and or unsatisfactory or inferior quality of goods as may be provided in the contract. So ito yung mga magbabagal na delivery progress, diba? Yung sa contract na parang dapat supposed to be by this stage. 6 months dapat nakaka 75% delivery na siya, pero hindi pa rin, nakaka 20% pa rin siya. So that can be considered ground for blacklisting, or pag yung mga dinedeliver niya sa'yo is substandard, di ba? Kaya crucial ang pag-aano natin ng mga pag-craft natin ng mga specifications, technical specifications, mga terms of reference natin. Kailangan malinaw, hindi siya yung updated dapat yung mga ano, kung para kita natin kung ano yung kita natin na dinideliver niya is inferior. Diba? Furnitures, yung nakabali, upuan ko lang, na isang parang higaan ko lang na gano'n, mababali ko, and that can be a ground for blacklisting. Next, for the procurement of consulting services, poor performance by the consultant of his services arising from his fault or negligence. Tapos ito, may fault or negligence lang si consultant. So kaya ka nga nagko-consultant, there are things na hindi mo alam, kaya ka nag-hire ng consultant. So, example ng mga poor performance by the consultant. So, yung mga effective design resulting in substantial corrective works in design and or construction. So, yung mga, di ba, mayroon kang consultant for the design of the building. Yung design niya defective. Di ba? And may ground for blacklisting. Failure to deliver critical outputs due to consultant's fault or negligence. So consultancy contact natin, mayroong mga outputs yan, mga crucial outputs. Kung hindi naman niya na ano yung mga outputs niya, hindi niya sasubmit. Basta fault or negligence na to is own fault or negligence. At walang fault or negligence dito si procuring entity. Yan. That can be a ground for blacklisting. Specifying materials which are inappropriate, substandard, or above acceptable standards. Yan. Diba yung mga design. Tapos diba may mga nagsispecify rin sila pag nag-design. Diba ng building, nagpa-consult yung design, tapos yung design niya, yung mga materials na specify niya doon sa design ng building is substandard that can be considered poor performance by consultant. Allowing defective workmanship or works by the contractor being supervised by the consultant. So, di ba, one of parang examples of our bidding for consultancy is for construction supervision. So, di ba, you need to hire a consultant to supervise the construction ng building. So, hinire mo siya para siya na mag-monitor ng construction ng building. Tapos yung tinignan nyo, minonitor na nag-procure entity yung building, parang defective workmanship, parang ang papangit ng pinagagawa. Despite merong nag-hire ka ng consultant to supervise the construction, that can be considered poor performance. For the procurement of infrastructure projects, poor performance by the contractor or unsatisfactory quality and or progress of work arising from his fault or negligence as reflected in the constructor's performance evaluation, system rating sheet, or the existing performance monitoring system of the procuring entity. Dito, nagkakaroon na siya ng negative slippage of 15% and above. So, di ba dapat pagkasubmit siya ng mga infrastructure projects, meron tayong mga Gantt chart, di ba? Yung progress of work, doon makikita mo yung doon makikita yung mga slippage na dapat for at this point, diba, 50% na, tapos 20% pa lang siya. Negative slippage na siya. Slippage na siya. Considered ground for blacklisting. Quality, performance, materials, and workmanship not complying with the approved specifications arising from the constructor's fault or negligence. Next would be willful or deliberate abandonment or non-performance of the project or contract by the contractor resulting to substantial breach thereof without lawful or just cause. Parang iniwan na lang niya, nakatiwangwang yung mga trabaho niya, hindi na niya kinumply, di ba? So, that is a ground for blacklisting. Case in this, it's determined yung FASI that the contractor has engaged before or during the implementation of the contract in unlawful deeds and behaviors relative to contract acquisition and implementation as enumerated in Section 3D of the Guidelines and Termination of Contract. Dito yung mga para makuha yung contract, be engaged in yung mga collusive, coercive, fraudulent, corrupt practices. Yan. Tapos umabot na siya ng contract implementation. Yan. Tapos yan, pwede natin maging crown. Pwede pa rin siyang maging blacklisted. Sanctions natin, performance security forfeiture for 1 year, for the first offense 2 years, for the second offense. This is without prejudice to the imposition of additional administrative sanctions as the internal rules of the agency may provide and or further criminal prosecution. Dito, kung ang termination of the contract natin is due to default and or unlawful acts, si Hope mag-i-issue ng blacklisting order within 7 calendar days after the termination of the contract. So, where the contract termination is no longer possible, but the contractor committed acts or causes which may constitute grounds for blacklisting, the implementing unit shall, within 7 calendar days of the lapse of the project duration, cause the execution of a verified report with all relevant evidence attached, subject to the following conditions. So, ito yung blacklisting natin, procedures natin. So, dito, makikita natin yung difference between blacklisting during procurement stage. So, dito sa blacklisting during contract implementation stage, nag-initiate dito ay si Hope upon the recommendation of the implementing unit. So, si Hope, initiate niya yung blacklisting upon recommendation of the implementing unit by a written notice to the contractor with the following information: yung statement of acts constituting ground for blacklisting, instruction to the contractor to explain or to show cause as to why it should not be blacklisted, and also includes special instructions of the PE, if any. Notice of blacklisting shall be accompanied by the copy of the verified report. So, yung report dapat, yung blacklisting dapat may report kasama doon. So, within the period of 7 calendar days, the contractor shall submit to the Hope a verified position paper stating why it should not be blacklisted. So, kung hindi naman siya nag-submit ng answer, nag-show cause after the lapse of 7 calendar days, either by inaction or by default, the Hope shall issue a blacklisting order. Kung ba, nag-file naman siya within 7 calendar days, the Hope shall, as 10 calendar days from receipt of the verified position paper, to decide whether or not to blacklist the contractor. So it shall serve a notice to the contractor of its decision shall become final and executory after the lapse of 7 calendar days from receipt of the notice of the decision. When does the blacklisting order become final and executory? If the bidder did not file an MR or motion for consideration on the decision to, it is actually decision to blacklist. Hindi suspended. Decision to blacklist, said decision becomes final and executory after the lapse of 7 calendar days from receipt of the motion notice of the decision. So final and executory decision receive the contractor yung notice, yung decision to blacklist, tapos hindi siya nag-file ng MR, nag-lapse ng 7 calendar days, final and executory na ang blacklisting. If the bidder did not file an appeal after his MR has been denied, The decision becomes final and executory after 7 calendar days counted from receipt of the resolution on the motion for reconsideration. Halimbawa, nag-file naman siya ng MR, denied, tapos na-receive niya ngayon ang notice denying his MR. So, we count 7 calendar days. So, 26 ngayon, 27, 28, 29, 30, December 1, December 2, December 3. Yes, until December 3 to file an appeal. Pero, halimbawa, after December 3, hindi siya nag-file ng appeal after yung receipt of this denial of the MR, the decision to blacklist shall become final and executory. If an appeal, however, but the same was denied, the decision becomes final and executory upon receipt by the agency and person or entity concerned of the decision on the protest. So, kasi since iba na yung decide dito, si appellate authority, so magiging final and executory ang blacklisting ngayon pag nag-appeal siya upon receipt of both parties, the procuring entity and the contractor of the decision on the decision to the blacklist, the appeal. Decision to blacklist. So, the decision to protest, no? Decision to blacklist. Ano na yung status ng blacklisted person or entity? Before issuance of blacklisting order, pwede pa rin siya mag-participate. Except, syempre, kung, halimbawa, na-suspend siya sa agency where he is suspended. Except in the agency where he is suspended. Halimbawa, yung blacklisting procedure was started during contract implementation. During procurement stage, doon, tapos na-suspend siya. So, pwede pa rin siya mag-participate sa iba, pero doon sa agency na nag-suspend sa kanya, hindi na siya pwede mag-participate. Mag-participate further. Nabawa naman, yung blacklisting order was issued before the issuance of blacklisting order. Tuloy-tuloy lang yung contract implementation stage. So, pwede pa rin siya mag-participate. Next, blacklisting order issued before the NOAA. So, the blacklisted person or entity shall not be qualified award and such projects shall be awarded to another bidder pursuant to RA 918. So, nauna na yung blacklisting order bago mag-NOAA. So, hindi na siya pwede. Halimbawa, na-blacklist na siya other agency, tapos meron pa siyang ibang project dito, hindi pa siya na-issuean ng NOAA, hindi na siya pwede mag-qualify ito. Blacklisting, what if the blacklisting order is issued after the issuance of the NOAA, no notice of award? The awarded project shall not be prejudiced by the order. So, tuloy lang. Award na, tuloy lang award. Provided yung said offenses are not connected with the awarded project or contract. Basta kung hindi connected. Basta hindi connected yung mga instances of blacklisting, yung mga grounds for blacklisting, kung saan siya na blacklist. Kung sa kontrata na yun, tuloy lang. Pero kung connected doon, it will be prejudiced. So, effectivity period for the penalty shall be clearly stated in the blacklisting order and shall commence on the same date of its issuance. How do we apply the penalty? So, previous remaining BO, halimbawa, meron siya 6 months, tapos na-issuance siya ng bagong blacklisting order, 2 years. So, ang isa-serve na niyang bago is yung 2 years blacklisting order. Masasubsume na yung remaining niya 6 years. 6 months. Hindi 2 years and 6 months is-serve niya, 2 years na lang. Dahil na-subsume na nung later blacklisting order yung previous remaining period ng blacklisting order. Pag offenses, diba, first offense, second offense, kung 3 or more, 2 years na ng 2 years yan. So ito yung blacklisting order form under GPPB Circular 3-2020. We download it from the website. It should not be modified. So yung mga ends ng blacklisting order form, department, office order, or board resolution number, complete registered business name, and failed JEPS registration number of blacklisted person or entity, license number, if applicable, authorized managing officer, name of project, contract, location, and amount, specific grounds or offenses committed, sanctions imposed, specific duration, and date of issuance of order to the police. And that concludes our discussion for today. Thank you very much.
At this point, we will be having our third and last knowledge check po. So, the question is, when does blacklisting order become final and executory? A, if the bidder did not file an MR on the decision to suspend, said decision becomes final and executory after the lapse of 7 days counted from receipt of the notice of the decision. B, if the bidder did not file a protest after his MR has been denied, the decision becomes final and executory after the lapse of 7 days counted from receipt of resolution on the motion for reconsideration. C, if a protest was filed and the same was denied, the decision becomes final and executory upon receipt of the agency and person or entity concerned of the decision on the protest. Or letter D, all of the above.
I-correct lang natin kung sa letter. Yung protest, palitan nyo po ng appeal.
The letter B po.
An appeal after his MR has been denied. Yan. Tapos if an appeal was filed and the same was denied, decision becomes final and executory upon receipt by the agency and person or entity concerned of the decision on the appeal. Dapat yung protest palitan ng appeal. On the decision to blacklist pala to.
We will be closing our poll po in 10 seconds. 10, 9, 8, 7, 6, 5, 4, 3, 2, and 1. So, sir, most of the answers po are all of the above.
Very good. Tama po. Ang answer po is letter D. Tama po ang majority. All of the above. Yan. Kanina kasi, yan na yung, those are the instances when the blacklisting order becomes final and executory.
That ends our second session for this day. So thank you so much, Attorney Atis, for facilitating an informative discussion on blacklisting guidelines. At this point, we will take a 5-minute short break, and after the break, our resource speaker will join us again for the open forum. So if you still have questions on the topic presented by Attorney Atis, please do drop them at the Zoom chat box. Of course, our viewers in Facebook Live may also drop their questions using the comment section. May we also remind our winners of the special tokens to please check their messages, and our event secretariat will contact you on how you may claim your prizes. With that, thank you and stay with us.
Ada control number kayo? Ada control number tayo? Oh, hindi pa ba?
point, we will be having the open forum. Our technical team has gathered your questions in the Zoom chat box and Facebook comment section. So may we ask our technical team to please flash the first question. Sir, we have one question each for protest mechanism and remedies and one for blacklisting guidelines. So the first question is, to have a strong case against erring public officer who committed acts enumerated under Section 65.1, what are the strong evidence to establish who will file a case and where to file?
So, for this question, strong case, what are the strong evidence to establish? Yung mga documents, so their best evidence rule, if meron kayong parang persons na pwedeng tanungan, you can present them in court. Diba? That can be a strong evidence. Mga documents din, who will file a case? It depends. Pwedeng si Hope, si Bak, or any officer of the procuring entity, or a private person can file, or an observer. Diba? Where to file? So it may be filed before, yes, sa ombudsman. May filed with ombudsman. Yan po.
Next question, please. Can posted blacklisting orders still be subjected to request for reconsideration?
It can no longer be subjected to request for reconsideration kasi final and executory na yung decision to blacklist. So, ang pwede nilang remedy would be certiorari under Rule 65. So, pero hindi na pwede sila mag-request for reconsideration.
Okay, sir. That's the last question po. And that concludes our open forum. If you have more questions, you may still ask them out even after this webinar by visiting slido.com. All you have to do is to just type in the event code #governmentprocurementph, to which the GPPB TSO will answer through an issuance or through FAQs. With that, we would like to thank our resource speaker, Attorney Atis, for graciously accepting our invitation to be part of this online training. Before we end our program, allow me to give a quick recap on our session for today. We have an in-depth learning discussion about the ground remedies of offenses committed in relation to procurement. We also tackled about the procedures and consideration on resolving requests for reconsiderations and or protest. For the second session, we understand about the procedures on imposing sanctions through the form of blacklisting and the responsibilities of the procurement actors relative to the issuance and posting of blacklisting order. Again, our today's session is led by Attorney Atis. Before we end today's session, allow me to make a few final reminders. We would like to remind again our Zoom participants to please register to the online training management system of the GPPB TSO and participants' daily attendance sheet through Google Forms by visiting the link shared to you by our event secretariat in our Zoom chat box. Rest assured that all information gathered for this online training shall be treated with utmost confidentiality consistent with the Data Privacy Act. We would like to thank all MLGUs for attending and participating in our 10 batches of the MLGU online training or RA 9184. I know that you have a great learning experience in the 5-day session in the procurement laws, rules, and regulations. Though I think 5 days is not really enough to discuss everything about RA 9184. As you go back to your respective offices, we hope that you may share to your co-workers and apply what you have learned from this training to help your office manage your procurement activities. This time po, mas well-versed na po tayo sa mga procurement rules. So to all our Facebook viewers na sumabaybay from first day of the batch 1 until today of batch 10, maraming salamat din po. We would also like to acknowledge the efforts of our GPPB trainers to Sir Ray, Ma'am Grace, Attorney Chan, Director De Vera, and to Attorney TJ, who have shared not just their knowledge but also their experiences in government procurement. Maraming salamat po for being our partners in capacitating our procurement practitioners. Please also allow me to take this opportunity to also mention all the staff behind the success of the 10 batches of the MLGU's online training. Ma'am Deep, Ma'am Laura, Ma'am Jo, Miss Kai, Monique, Marky, Malu, and Taj of the Capacity Development Division, Sir Randy, Miss Michelle, Jen, and Sir Audie of the Information Management Division, and of course, our beloved Executive Director 5 of the GPPB TSO, Attorney Rowena Candice M. Ruiz, for all the support throughout the entire run of our online training from September 6 up until this day. So before saying our goodbyes, may I request everyone to please open their cameras for a group photo opportunity. Ayan! Ayun, hello everyone! We will be taking the shots po in 3 shots. 1, 2, 3. Another shot po in 3, 2, 1. Ayun, isa pa po. 1, 2, 3. Thank you, everyone! Thank you, Attorney Atis. Thank you, sir.
Thank you. Thank you. Isa inyo. Bye po.
Merry Christmas po to everyone. God
Merry
bless.
Christmas.